Hi, everybody. I think it's about time to get started. We have a pretty tight schedule, so we'll just get things moving. Before we start, I just wanted to ask if once the negotiation starts, if you're in this room, if you could just do your best to stay in your seats just to minimize the disruption. I understand that things might come up and you might have to step out, but if you could just try to do good by our competitors and minimize disruption during the negotiation, that'd be much appreciated. But yeah, good afternoon, everybody. Thanks for being here, and welcome to the 2025 Halloum Business Negotiation Competition.
We are so thrilled to have you all here today. I'm Adriana Mendez, and I am representing Berkeley Haas.
And I'm Andrew Park. I'm a 3L at the law school. We've had the pleasure of being this year's student directors, and we're excited to kick off today's final round.
The Halloum Business Competition is a one-of-a-kind collaboration between Berkeley Law and Berkeley Haas. It bridges business and law through hands-on team negotiation.
Over the past month, our competitors have tackled multiple complex fact patterns and taught themselves new concepts, and most importantly, refined their negotiation skills.
The goal is to help students connect with their future colleagues and practice real-world negotiations in a collaborative educational setting.
And before we get into this round, we just wanted to take a moment to thank the competition's founder, who is also here today as a judge, Joseph Halloum. So just thank you.
So we began this journey with 20 teams, and now it all comes down to these two teams up here.
Our finalists here have navigated 3 sets of evolving fact patterns and have shown creativity, teamwork, and composure through every round.
Now, counsel for these two companies are sitting down for their final negotiation, their last chance to iron out the details and bring home this deal.
So let's wish both teams the best of luck, and we'll begin the final negotiation round.
Do we start, or will you all start us? I guess we can start.
We can just
Okay,
get
cool.
started.
Ready?
Yeah.
Ready. Let's go.
So, thanks for being here. To just set the scene of the negotiation, I think both of our companies have a lot to gain from this agreement. Just to iterate upon it, I think for OmniMind, we would get some certainty out of the agreement, and we'll reduce some reliance on outside vendors for our data, and we'll get the excellent technology that you guys are building. But at the same time, Datasphere has a lot to gain too. You'll get the capital you need to get this innovation up and running, a global distribution channel through our company, a really good CRM infrastructure, and much needed stability. With that, we have prepared a first offer, and we are ready to present that.
Okay, I think before we go into offers, I'd love to just discuss some points. I'm Gavin, this is Christian, and we're representing Datasphere. And so we're also really excited to be here with you today and to renegotiate. I know we came to a valuation earlier of 10 billion, but that is not going to work due to some recent challenges. So we're very willing to discuss with you a different valuation. We appreciate your patience and flexibility in doing so. To get it out of the way, I'd love to just go over some of our priorities here. We have 3 main ones. Number 1 is reputation. We want our reputation at the forefront of the field and as best in class to be upheld, undamaged by recent client loss and the litigation and regulatory risks. These threats to us have a lot more to do with public perception than they do actually have real risk to our platform or IP. But we also want to make sure that you feel comfortable with those threats as well. We definitely want to signal to our clients and shareholders that we're in the same place before when we decided on that 10 billion valuation. Second, we want to close this deal as soon as possible. It's just important for us to be able to move on. Closing quickly will allow us to focus on current potential threats and settling into our new role within OmniMind structure. So that's also important to us. And we think the more time we spend closing this deal, the more time, focus, and resources are wasted while we're in uncertain territory. And then third, we really want to be prepared for the future, have contingencies. This is an opportunity, regardless of whether the threats right now are relevant or dangerous. This is really an opportunity to use our reaction and handling of current issues to determine our responses when future threats rise. That said, I would love to hear more about your priorities and what you're thinking about going into this deal.
Sure. And these are some of these are priorities for us as well. Um, some of the terms that we would like to go through are the valuation, of course, like you mentioned. But you mentioned like uncertainties and the speed of the agreement is important to you. So I think going through the escrow, how we deal with regulation, and finally just ironing out some details around termination fee would make sense.
Before we proceed, specifically with the changes that have happened since we were last at this table here, we wanted to hear, do you have any specific concerns? Can you maybe elaborate on your uncertainties that are moving you away from our initial package?
Yeah, as we go through our first offer, we'll provide you some justification and also why we're doing this, and this will help address some of our concerns and also let you know some of our priorities as well.
Okay, great.
Think
Are
that
there any issues on your ends that you feel will make the deal difficult to go through with?
well, there are new risks that have entered in the recent terms, such as the loss of one of your major clients. So we would have to go through a little bit of that. Also, the escalating and changing litigation environment around the IP. And finally, the new AI regulations that governments and other institutions are pushing, and how we address that as a combined company.
Yeah. With regards to client loss, are you concerned about that being a problem in the future? Because from our perspective, this is just a one-time thing. We're not concerned about it being a pattern. If we look at what we're currently being regulated for within California, it's mostly we're being regulated. They're reviewing contracts with healthcare clients. And so far, even though they're reviewing those, none of our healthcare clients have dropped out. It doesn't seem like there's a concern around that. So in terms of future client loss, we're not as concerned.
Well, this was one of your major clients and a really big chunk of your revenue. I believe it's around 9 to 10%. And based on that, we would like to change the valuation that we were offering from $10 billion to $7.5 billion.
Okay.
But this is not just to address the loss of client, of course. But however, these new realities, such as the loss of revenue, but also the reputational hit you take from losing a major client, increased threat of litigation, and these increasing regulatory pressures, these are new pressures that would be need to be reflected on this deal as well. But given that, we can have an escrow for 7% for 5 years. My colleague Scott here can expand upon that a little bit.
So
as well.
as I understand it, we've already decided on escrow.
Exactly. So 7% for 5 years stays the same. We only ask and we offer that it also would include regulatory fees or
Okay,
fines.
What would that look like?
So that would look like if Ireland decided to fine us, or the California government finds that there's something wrong with the healthcare, the way that you guys collect the data, anything. The fine would come out of the escrow as well. Before, it was only protecting patent litigation.
Yeah, so we're giving you some more room so that you can maneuver within the escrow a little bit more. We realize 7% is a lot of money that would be in escrow, so making it be usable for some additional things would be nice to you, and this would get us ahead of some of the financial burdens that we would have during litigation and regulation as a combined company, because we are really looking forward to have this deal with you. I think both parties have a lot to benefit from each other. And dealing with regulations, we think a shall comply language makes sense, given the AI is a hot topic right now, and every government and institute is looking to regulate that.
I do want to push back against that quickly. We just wouldn't agree to a shall comply language, and we can discuss other options that would make you comfortable with the regulatory issues. But just to make sure that we don't press it too hard, that's not something we would agree to. But please continue with your
Sure.
package.
So we would also ask for a quarterly report from the OmniMind Regulation Committee. We'll put an asterisk on that because I would like to circle back on the reason why a shall comply language would be a no-go, as you propose. Lastly, we propose a termination fee from our side for 1.5%. The $112.5 million approximately would cover any fee that you have incurred till now, as well as try to address some of the media attention that you would get from if the termination would be to happen, which we won't like that to happen. I think, as I've been trying to say, both of our companies have a lot to benefit from this situation.
Great. Just to clarify on your initial offering here, so with the escrow, you're just looking for the regulatory fines that's being pulled out. The rest of it, in terms of like control, like who's in charge of litigation, we're going to continue with us being in charge?
No, we have more to say on that.
Yeah. Here, we'll just write that down real quick.
Okay.
Actually,
I think
I think it would be good for us to just start with
Yeah.
valuation, and then we can
Yep,
go
good
down
idea.
and discuss
Yeah.
other points later. But we have a lot to say on how we valued our company as well.
Sounds good.
Absolutely.
so. I think we could definitely agree that the valuation has come down. So I kind of want to just go an overview of how we initially had our original valuation and be a little surgical, like how we can adjust it with the changes.
That's good.
So initially, right, we had a $10 billion valuation that we agreed on, and we came to this from some form of, let's say, a forward revenue model with a multiple, right? Some multiple value. And we had settled on, in this case, looking at our forward revenue for 2025 of $250 million, and then a multiple of 40, which got us here. So I guess before we go into this, I just want to kind of restate one of our big priorities in terms of reputation. The way we see this is, for us, it's really an important signal with you guys being on our side that we actually keep this number kind of on as face value. But we understand that from these changes that have happened, the pullout, the actual financial value that you guys are willing to pay is going to be lower. So we're going to look at like a present value, right? Like what is the value of this deal today? And through some creative deal structuring, we can get to a lower present value, right, which would satisfy your financial needs, but would still allow us to maintain our reputation, right, by having that $10 billion valuation mark. But we were thinking here that we agree with the pullout of our client, right? This went down to $227.5 million. But we do think that lowering this multiple here is a bit of an overreaction. This is a singular client that moved out, and it's not like a reflection of necessarily a change in our growth, right? This came from looking at the base benchmarks that we had with a 92% growth, now down from there. So we actually think we'd like to keep this, and that gets us here at 9.1. Now, this is what we're looking at as the present value that we're trying to tackle. And we wanted to kind of present two options here that we want to kind of ask what you guys are leaning towards. First one is looking at using a combination of cash and then stock, right, with some lockout periods, meaning that we can't sell the stock right away. So this would be OmniMind stock plus stock. I don't want to get too technical in terms of like the duration, so we're doing a lot of math, but we get the point. Combination of cash plus stock and lockout, right? And then B is going to be cash plus deferred payment. And we can talk in terms of like details for what we would do to get to this number in terms of like the time for deferment, as well as like a discount rate on the cash, as well as a discount rate on the stock. But these are the two options that we're thinking will help us maybe close the gap between our two numbers. Is there some alignment here with being okay with even that like that face value here for our reputation? This is again very important to our side.
So just to clarify, it would be 9.1 billion in cash, and then
So it would be no. So to give you an example, this would be, for example, we would do 6.5 billion cash in this example here, and then this would be 3.5 billion in stock, and then this lockout time here would have been 2 years. So in terms of this would get us to a present value today for 9.1 billion, right? So in terms of like what it would cost you guys, it would be this amount.
I do have a question actually about that 7.5 billion number. I don't know the math off the top of my head. So what kind of multiple were you working with the 7.5?
So the 7.5 billion valuation, as I was coming to it, just doesn't reflect the like forward revenue plus multiple.
Okay.
The space that we are engaging in, AI, like the multiple, the number itself doesn't have very much inherent meaning, especially if you apply to forward revenue. This was taking into account the 9.1 billion valuation if you were just to take the multiple with the amended forward revenue. But we also want to take into account the risk that OmniMind is taking from increased litigation and regulatory oversight. And that would have material costs as well as reputational costs. And I think the amount of extra effort and engagement that we would have to do to deal with these issues reflect more fairly with the 7.5 billion valuation. And we understand that reputational risk is a big factor for you. And we have a version of a deal prepared that I think would be satisfactory for both the parties. I think we can stick with the $6.5 billion cash that you suggested. But instead of doing a stock lockout directly, we can do a $1 billion stock option and a $2.5 billion revenue recapture. So we can set aside some revenue targets and technology targets that you would be hitting over a defined period of time. And once you have that, that would give you a $10 billion valuation. So from a media point of view or a reputation point of view, we can project that it's a $10 billion deal, but the cash exchange would be $6.5 billion with a $1.1 billion stock. We agree with the 2-year lockout. I think that makes sense. And the $2.5 billion revenue recapture, I think that makes sense because that would satisfy both of our requirements of having a public $10 billion valuation as well as making sure that the risk that we are taking is also addressed and we have some mitigation strategy in place to address
What
that.
is the revenue recapture here? Can you, how does that work?
So for example, we can do, if you were able to get an additional client on board or several clients that could replace the company that has left. And also hit some revenue targets on the way.
Okay, so you're looking at basically some metrics that we would reach, and then to get there.
Exactly.
And then upon reaching those funds would be released.
Exactly.
Okay.
I definitely think we're going to gain some new clients from this partnership, but I don't know if we would want a contingent on like a certain amount of client gain.
We can discuss the deal of the exact how revenue recapture would look like, but this is a structure that would, I think, would be more secure for our company
And protect the reputation
of your
Datasphere.
company as well. I think it's a win-win situation.
So I think maybe for time's sake we should move on, but I guess to recap, I think we've aligned on being able to keep a $10 billion just face value, right, for reputation, and then lower the present value here with some stock options and lockouts, as well as having a recapture plan to lower the risk on your end that if you satisfy it.
Sure.
Sounds good.
Let's kind of maybe put that on hold and we can kind of flesh out details. We wanted to talk a little bit more about escrow. Gavin?
Yeah, I think for us, the 7% seems a little bit excessive. With regards to the LabelWorks claim, we don't believe they're actually a significant contender. We kind of look at them as a patent troll and not a significant threat. So we think this kind of escrow agreement is more symbolic of how we should approach potential threats of litigation in the future. So we would be interested in decreasing the escrow once the LabelWorks potential litigation is off the table. And then I think we would also want escrow to decrease based on time. So we could do something like a 1% decrease yearly, and then we could do a 3.5% decrease once the LabelWorks is off the table.
maybe ask why you think the litigation is not a
Yeah,
major issue?
It hasn't been thrown out. It's continuing to be litigated. And as far as
Well, it's not litigated right now.
well, it hasn't been thrown out of court, right?
Oh, yeah,
Yeah,
sure.
and,
But it's in early stages, and so we don't believe it's going to get very far.
well, if we want to go through, we have like several real-world examples where these lawsuits have gone for ages. Like Scott can go through them a little bit if you want to.
Yeah. So Alpha Modus is a company that is doing pretty much the same thing. They're suing companies just like yourselves, pretty much monthly. These cases are not being thrown out. These are very technical cases that require a lot of time and a lot of lawyers being paid. And so that escrow has to stay at 7%. We can talk about early release if this case is thrown out. We are willing to, lower and release some of those funds. But
Sure.
yeah, that number has to stay at 7.
Oh, yeah, the 7 is already decided as like.
Oh, I thought you said you wanted to drop it to 6.
Oh, it would no. I
Oh,
mean early
like
early
a times
release.
Oh,
in
okay.
terms of-
Understood.
Yeah, but no, we don't need to drop that.
Okay.
But I think it's also good to discuss like control of litigation if it does go that far. For us, we would want to have control because Elena believes it's really important for us to maintain our reputation here, and we also have more technical expertise and familiarity with our own patents. So,
Well,
Christian, did you
just a
wanna say
little
something? Sorry.
pushback.
Let's hear that.
Yeah.
Our brands will be combined, so our reputation will be attached to Datasphere's. It's just more efficient from our perspective, just to handle all the legal issues from our situation, our firm.
Yep.
Sure. So I think then we understand that, but respectfully, like our engineers, our team, like they're the ones who are working on this product. These are the ones who know it. But we do think there's an advantage with combining our resources here. So I think we would propose having, and this is again an important point for us, just for Elena reputationally. She thinks like kind of being at the face of this is a symbolic move, not only for our current shareholders, but for our clients and the rest of the world, right? To show that you guys are behind us and that this is not necessarily serious, that we don't believe it is. We think having you guys as a secondary counsel and then allowing, to still leverage your expertise while still having kind of forward-facing our team would be the right move. It'll allow us to, we have, some very technical understanding of our products, right? But we can also use your experiences. I'm sure you guys have, had people go after you as OmniMind has grown.
On that point, like we would like to maintain more direct control over the litigation.
Yes.
So I propose, we are proposing that we can agree with an early release. So we can release approximately 30% of the 7% escrowed amount.
Wait, sorry, 3%.
30% of the escrowed amount on the conclusion of the
Okay.
label works.
Wait, can we just discuss in percent like from the 7%? Because I don't know what 30%.
So
of that
let's just say, 7% of whatever price we agree. So I think it was like 500 million, something like that. So upon the conclusion of the label works case, 30% would be released of 500 million.
So that would
Roughly
be
speaking.
$160 million would be released. So you would have more breathing room to use that for research and development and other company operations.
Before that, we would need control over settlement agreements and litigation strategies. Another compromise, we could hire some of your guys' experts and make sure that they're on our legal team so we have the expertise that you guys are concerned about.
I guess, just as I understand, what is the priority here with you guys being in control here? Because I think we've communicated that for us, there's a reputational factor in terms of having Elena and her team, and she just believes she could best protect the technology by having her experts there. That's really our priority. Like, what is your priority in terms of like having the final say and having like?
Our priority is just protecting our company. And so if you want to be like the face of the litigation, if that were to happen, that is agreed upon, that should be fine. But as long as we have control or expectation, direct control over like if there's any agreement or if there's any settlement to be done, we we get to weigh in on that heavily. We don't necessarily are concerned about being the face
Okay.
of litigation.
Yeah.
But as you know, like as a combined company, it would be
We understand.
both of us are being represented, not just OmniMind and
Okay.
not just Datasphere. And your reputation would be attached to our reputation too. So we understand the reputational risk you would be taking, but you should take into account that we would have a combined reputation at that point.
Okay, so if I'm hearing then this properly, you guys would like to say on settlements, and then what was the other thing that you guys like really need
And strategy.
And strategy, but you're fine having Elena and her team be the primary counsel as long as you guys have like say in this.
Yeah.
Yeah.
That's
We could give
We
you
can agree.
approval
Okay.
rights for that for sure.
Yeah, approval
Yeah.
rights, yes.
I think as long as our team is allowed to have control of the litigation, we can give you approval rights for all of that, like settlement, major strategy points.
Sorry, so what does control here mean for you?
We would want our team to handle the litigation, and you could be on as secondary counsel, but you would still get approval rights over like if there was a settlement happening or if there were any major strategic moves. We would.
Yeah, can
Yeah, we
agree.
can agree with that.
Great.
But for that, we would have to press on the shall comply plus quarterly reports for regulation. We already, sorry, just to continue, we already carved out regulatory fines
Yeah.
protection within the escrow. And I think that would enable us to actually start complying with some of the landscape of AI regulation we know is like evolving really, really fast, but we don't want to be blindsided by any government fines
Sure.
or any other bodies. And we have a really strong regulation committee already, being a social media company. So we would like to provide you the help that you need, but we must insist on the shall comply, at least for existing laws. And then best efforts for any new regulation that can happen, because as we said, like AI regulation is changing quite a bit, but this is something we want to stand a little firm on, shall comply.
Okay, the reason why I pressed against that when you put that on the table is that it's like something that is kind of a deal breaker for us. We can't agree to that.
We can.
And that's because since the regulatory space is so in flux right now, that would make us liable for a lot of gray areas that would be really significant, and it would be dangerous to our survival.
Yeah.
I think this is also an opportunity to reframe the risk here. Like, this is an opportunity for Datasphere to get ahead of the game and be in compliance with any potential new regulations. And we believe we're being targeted because we're at the forefront of the field, not because of anything specific
We
done.
as a company totally understand that. Like OmniMind has been in that situation before, and that's why we are requiring a shall comply for laws that are already existing, and best efforts for laws that might come in the future. But because the regulations that are already happened, I think it's reasonable to ask for a shall comply for those because they have been out there.
Okay.
And we understand that AI is an evolving field, and there's a lot of gray area that we need to tackle, and it's very hard to predict, especially with government being trying to set an example, being like a little aggressive on AI regulations too. So we totally understand that. So shall comply for existing laws and best efforts for new regulations.
Okay, so we'll have it on the table right now. So I think where we kind of moved from the regulatory, the escrow was, we came to an agreement kind of on the primary, you guys are secondary, you guys have approval rights and strategy, and then settlements, but you'd like to shall comply. I think we should talk about regulatory governments now. So our point of view here is that because it's shifting, right, that these laws, if we agree to a shall not comply right now, that we would be liable for things in the future if these laws change. And actually, we think that would be a harm for both sides. But we do hear your concerns about this environment shifting. We have a proposal that we think would address that. So we're willing to commit to commercially reasonable efforts to comply with GDPR and CCPA and similar laws, and also prompted you guys with any notifications of inquiries. And we're also willing to give you guys a third-party auditing team to give you guys assurance that we're not breaking anything like as of right now for due diligence. But we actually think we can turn this spotlight on us into a competitive advantage for both of us. So we looking at other companies who are in this AI and regulatory space, looking at like Anthropic or Adobe, something they've done is they've seen this regulatory that's changing. They think at some point in the future it's going to be settled, but to take advantage of that, they're going to get ahead of that and like develop their own policy and strategy teams to understand what's going on so they can adapt, right? So if things do settle, they've developed these AI models that are in compliance the whole time and gives them a strategic moat. We think this would be a good time to actually announce a similar safety and policy team, right? With this changing landscape, as we both know, this will allow us to stay ahead of any changing laws, as well as also signal to our clients, signal to our investors that regulatory isn't going to be a problem in the future. And I think it would be a really good show of faith for everybody who's already put money into this, that we do so.
We can agree with the Joint Regulations Committee to study new regulations and deal with them, but we have to insist on shall comply for the existing laws because they're already out there. And you mentioned that they might change in the future, and that's what we are taking into account when we say best efforts for new regulations. We agreed to a third-party auditor for your regulations too, but we don't want to trade speed of innovation for drudgery of paperwork here. So shall comply for things that already exist. I think
we should, because we're not going to agree to that, so I think we should just move on to reverse termination fee for time.
Yeah, let's.
I have a couple of like not exactly packages, but points prepared. So for our consideration, we either would want you to have like a flat reverse termination fee that reflects the risk involved with y'all potentially dropping. And so for flat, we would ask for termination. For flat, we would ask for 6%. I understand that's kind of high for you, and you were looking for something lower, but in terms of proportion, like the 3.5 for us would be a much higher risk than a 6% would be for you, since you're such a massive company and you have a lot of resources. And we do believe you're at a higher risk of dropping out of this deal. Alternatively, we would be willing to match our 3.5%, but we would want that to climb based on how far we get from close. So we would do 3.5% for the first 2 weeks, and then every month after that. So after that, we would gain 1% for the reverse termination, and then we could cap it around 8%. So with this, this would ensure that if you do drop out, you would drop out earlier, so we wouldn't spend too much time spending focus and resources and effort on this. And otherwise, I think it would incentivize us to get this deal done as fast as possible. Do you have any thoughts on those numbers?
Yeah, that's it would just be a lot of risk for us.
Okay.
Starting at 3.5 is a little bit more reasonable because that is what your current cancellation fee is. But is it every 4 weeks it would bump up 1%?
It would be every 4 weeks, yeah.
That when you translate this into actually how much it costs, that is a ton of money, and we really need to protect OmniMind. This deal in general is about risk. And we need to be able to show our investors and that we are doing what we can do to minimize risk.
We can, we in that line, we recognize that we are at a high risk for dropping out the new. We see that. We can propose a 2.5% cap, and the new can match it too. So whatever you're willing to match between 1.5 to 2.5%, we are willing to do that as well to a cap of 2.5%. And if you want to go to 3.5%, then we want to do a 3.5% of the cash value that we would be offering initially. So not the valuation, but the cash offering.
Okay. From my understanding, we were already agreed on the 3.5%. And so is that not something you would be willing to match and then potentially have it increase in the future?
We can match at 3.5%, but only if we consider the cash component of the valuation offering. But otherwise, if you want to do a total valuation, we are happy to match you at 1.5%.
Okay.
Not match you, but like do 1.5%.
I think for the sake of time, why don't we both take 2 minutes and put together another package taking into some of these numbers
Sounds good.
into
Good idea.
account,
Yeah.
and then we can come back. Okay, cool. We don't have a lot of time, so
Okay.
why don't we discuss valuation quickly?
Yeah. So just to go on valuation, I think ours is pretty reasonable, especially with the initial ask that you had. $6.5 billion cash, $1 billion stock, and $2.5 billion revenue can recapture.
I think, yeah, we like the 6.5 is okay as long as more of it is in stock than with recapture.
Well, I know you guys also believe this, and we believe it too. You have the potential to recapture the revenue that you lost really, really quickly. And the details would be decided later. But this is a show of faith in your capabilities to recapture it quickly, and that will present us a way to mitigate a little bit of risk on our end too. I think $2.5 billion is a very reasonable ask, and $6.5 billion cash, $1 billion.
So
As well, it preserves Datasphere's reputation, which I know is a big
yeah,
thing.
Yeah,
no, we
that's
hear you.
primary
I think
concern.
we would be more amenable to this if you would be more amenable on the regulatory side in terms of the shall not comply.
So we heard you, and so we are proposing a broad best efforts for everything. So for current laws and upcoming laws or any regulations that might change, but we must insist on then the committee that you propose and we agree to, as well as quarterly reports with external auditing agency, and lastly, some carve-outs for extraordinary judgments that might come out of regulations.
I think we could agree with that if you would be willing to do the termination fee at a 2.5 match, but it still goes up 1% every 6 weeks.
That would be,
Yeah, can we start that at 2%?
I think we can.
2.5
go
is
lower
steady
than
for you
that.
guys.
Yeah.
I think we believe our cap is 3.5 billion of 6.5, 3.5% of $6.5 billion.
Okay.
So we are offering you our best here.
Okay.
And
Why don't we discuss escrow then quickly? I think we came to an agreement on us having control, you have approval, and we're willing to do the 30% release with the Label Works litigation close. And we're also in agreement on the 7% for 5 years.
I think we are in
Right.
broad
Okay.
agreement for the escrow and litigation. But we must insist on the termination fee of 3.5%, and also regulations was an issue, and I think we solved it. So we insist on the valuation that we're presenting as well.
Okay. Well, I think we've run out of time, but I really appreciate that you were able to come to the table and we got a deal on escrow here, so we can discuss the rest of the deal points at a future date.
Absolutely. Thank you so much.
Thank you.
Our
Thank you, guys.
companies are going to do great together.
Yeah,
thanks.
we're excited.
Great.
Okay, so thank you to both teams for that thoughtful and strategic discussion. The students will now step out for 3 minutes to prepare their post-negotiation analysis, and we ask you all to please stay seated because you will not want to miss this next stage. As they break down their strategies and their takeaways from the negotiation you just watched. So both teams, if you can please exit, and we'll call you back in about 3 minutes.
So I guess starting with like opening and our priorities, I think it was just important to get those on the table so that we could frame some of our arguments later with those priorities. Especially important was reputation, because that was something we could use for all four. But then like the coming to a deal quickly thing was something we wanted to use for the termination fee. And then our last one was like looking forward and figuring out how to plan for the future. And I think that's something we used mostly for litigation, but also for regulation as well.
Yeah, so I think initially we spent a lot longer on kind of we had some questions. We were hoping to get some more answers in terms of like what mattered to them. Like we're really trying to press and understand with the regulatory concerns, with the this risk, right, that has been increased, like what specifically it was. Because we felt like we had kind of anticipated what that would be, and we're ready to answer that with the our regulatory package that we put forward. We did feel like we did see that they changed some of their offerings in the end, so we were able to provide that. I think in terms of like kind of reflecting on the overall structure, I think things went slower than we thought it would. We also anticipated, we like to talk. We're sure they like to talk, and it would just take longer. But we were hoping to maybe go through, and rather than having a whole package, have the opportunity to kind of justify each. We understood that at some point we would be looking at packages and trade-offs. I guess starting with like valuation, our priority here was really to. I think one thing we did well was we got across our priorities in terms of maintaining that face value of $10 billion for the reputation and why that mattered. And I think that was something we felt like they would agree with, as long as like financially, right, the actual amount they're paying is lower. And it ended up being, I think, less of a discussion on the kind of structuring. They had the revenue recapture. That was something we also thought we could throw in. We might throw in later, but they threw it in earlier. And we didn't want to get into a discussion about math.
What did you base the 40 multiple on?
So the 40 multiple was something that
We were given it in our facts.
Yeah.
Like we just had the 10 billion, and then it was just like forward revenue times a multiple. So that's what we had been using for previous rounds, and I think that's what other teams were using as well.
But to give some more like rationale, like how do you get to that 40 multiple? It was looking at other like high growth companies. So we looked at our growth rate, we looked at our EBITDA, and seeing what other companies that had like gone through similar deals, what their multiple was, and that's how we came to 40. So you could kind of like back calculate like how we got to that. Our initial goal was to kind of have a reservation of around 36 if we needed to, which gets us to about 8.2 billion. And that comes from like a company that had a lower growth rate, that's 70 versus what our 75%, and then using the new forward revenue right after the Atlas pullout. But I think with their opening on like the amount, we felt like it actually wasn't too far. So we didn't think we'd have to like go, it'd be too difficult to get an alignment on the valuation. And we sort of did here with with how we structured it. We didn't finish a deal, but getting to like where we were with the having stock and then a revenue recapture, I think we took some more time. We probably would have traded off a little bit more and gotten to a yes.
Did you think about splitting the difference? I mean, at the very end there.
Yeah, that was actually so our plan was if we didn't have the revenue recapture, it would be whatever that difference was, we'd throw that in revenue recapture. Because we thought we would more argue over like stock and deferred cash, but that was our backup plan to whatever the difference was, revenue recapture, and then.
I think I was kind of the holdout on that as well, because I was worried since we didn't have the actual terms of the recapture, we weren't completely sure if that was really something that was feasible. So the fact that we just kind of said, okay, we decided later we wanted recapture to be lower than our other options.
I think so. Moving forward, we actually kind of want to skip the regulation because we didn't get to talk a lot about it. So this was kind of like we thought would answer a lot of their challenges with is Datasphere, this is a Datasphere problem versus is this like an industry problem? How are you going to handle with like the changing laws and regulations? 'Cause that's a real challenge that companies are facing today, and like scoping the market, like what are people doing? Like how are they handling this? And maybe how can they turn this into an advantage? So we really like the idea of having like the safety like and policy committee. They sort of combined it with their like internal committee, but we saw it as like not just something we're adhering to, but we could use that as a strategic position. It would lower the risk and actually potentially increase our value over time, right? You look at Anthropic, right? They just had a partnership with Novo Nordisk which deals with a lot of like healthcare and sensitive data, but they're only doing that because they're confident that their models are not going to be compromised with that sensitive data. Adobe is doing the same thing with their generative AI features and not allowing, setting it up so like you're not going to be an issue with copyright, right? If you're using that to produce something in a movie, right?
Sorry to interrupt. That concludes your guys' post-negotiation. We'll go grab the other team and keep it rolling.
Oh yeah, because we only have this.
All right.
Thank you.
Should we just get started?
Go for it.
So coming into the negotiation, we we both understand that it's not about winning. It's about coming to a term that's mutually beneficial, and it's something that can last. And that's why we addressed the concerns of our clients, which was having access to this technology that Datasphere was building, but also to mitigate some of the risk that has been mounting on through litigation and regulation pressure. And meanwhile, we also heard Datasphere, and their concerns were around public image, reputation, how fast the deal closes, and uncertainties. And we believe our offer best reflects a deal that would address both of our requirements. The valuation that we offered were generous, but it also had caveats built in a very creative way for them to earn their keep. So it will give them initially less cash, but it'll help them by setting some revenue targets. It'll help them recapture some of that revenue. By capturing that revenue, they will recapture some of the valuation.
Yeah, exactly. And we wanted to set the escrow that would protect us, but also give secessions that they would allow for greater carve-outs and greater protections for regulatory fines. That was one of our concerns was, all these regulatory bodies are looking, and the escrow from last deal didn't include any regulatory fines. So we wanted to make sure that that was built into a new deal. And
we understand from a regulation point of view, this was their concern as well, especially in a field that's ever evolving. So I think we did a good job in protecting the interest of our client by ensuring that we are offering a deal that's best efforts, especially in a field that's evolving really, really fast and regulations change on a weekly to monthly basis.
When you did best efforts for regulatory compliance, why wouldn't you want the other party to comply with laws just full stop and do the shall comply?
in our research, we calculated that to do the shall comply, it would lead to a very, very expensive compliance program. And so we wanted to anchor our negotiations with shall comply, but give ground when necessary. And so, AI is a constantly changing. Chetanya can speak more on that, and it's very hard to do a shall comply term.
Yeah, especially like best efforts would enable them to move nimbly too, especially in a field that's about moving fast. And as a partner and as a joint company, their breakthroughs would benefit us greatly, even though we would have to be involved in slightly more litigation. But the upside that we calculated by reducing the amount of regulation fee, as well as the potential upside of getting a breakthrough technology, we thought that it was prudent to go to best efforts from a shall comply.
Yeah, moving on to the termination fee, or I'm sorry, moving on to the litigation control. Our main concern was making sure that we had a veto over settlement amounts. They obviously are correct. They have a lot of specialty knowledge that they can litigate the technical patent issues better than we could. And so we were willing to give ground on that as long as we had veto over settlement amounts.
That offers us the protection that we need, as well as giving them the opportunity to put a brave public-facing front, as well as for our joint company to present a unified front as well, but while also protecting our shareholders. And lastly, termination fee. They did really well in recognizing that they are at a lower risk to terminate the deal than we are. So that's why we offered them a deal that they can agree to, like by matching their termination fee. I think that would give a more fair evaluation, especially if we cap that at like 3.5% of the cash offering that we are making them. So by tethering these two options, we gave them opposing numbers, such that they could have a low cash valuation if they wanted a high termination fee. So it was self-balancing in that way. We try to make our offers generous because our value of the deal is not coming through just saving money. It's coming through the technology primarily. And it's also by being generous, we can come to a deal faster. But our priority is also to mitigate risk, as we are saying. So we
Apologies
stood
to
out.
interrupt, but that's time for your guys' post-negotiation analysis. And that concludes our final round. So for right now, the judges will take 5 minutes to score and deliberate. I'll bring the other party in. And if you guys want to stick around and hear the feedback that the judges have for our competitors, you're more than welcome to.
Okay, guys, so you are about to receive your feedback from the judges.
Hi. Overall, I just wanted to say both teams did an incredible job. I was really impressed with the overall discourse from both sides. For the Datasphere team, I thought you. Oh, thank you. I thought you did a really good job setting your overall priorities in the beginning and tying each of your proposals back to those priorities. Thought that was a really effective strategy and way to frame each of your proposals. So great job there. For the OmniMind team, I thought you guys did a good job with coming up with solutions that minimize kind of cash out of pocket and the risk for your teams, especially with the valuation proposal and your the recapture for the revenue. I thought that was a great solution that, addressed their points. I thought it would have been great if you guys at the beginning, the way that they had kind of framed their overall priorities, I think that would have been a little bit helpful as well. It seemed like you guys want to just dive into your proposal. And while that helps kind of move things along to a certain extent, I think sometimes just setting the stage so everybody understands where both teams are coming from is a great way just to kind of build a rapport at the beginning and just make sure everyone kind of understands where everyone's coming from. But again, overall, I thought everyone did a really great job.
I totally agree. I think overarching thing, I've never said this for one of these competitions before. I really wish there could be a tie, because if there ever was a year where it would be deserved, it would be this one. I haven't seen this level of analysis, of maturity and teamwork, both within the teams, across the teams, and so I was very impressed. Christian, fantastic job putting the financial analysis up there, providing the different scenarios that you did. Gavin, I loved how when you heard something that was just a deal stopper for you, you were very quick to cut in and say that's not going to work for us. And I think it's good to do that sometimes and not waste time and really anchor and position your thoughts on things. I don't want to butcher your name, Chetanya. The revenue recapture sounded like an earnout. I thought that was a very clever, good solution. You both were very conscious and understanding of the optics of the headline number being 10 billion and being thoughtful about finding a creative solution. Scott, you were always, I think, level setting on things and providing rationale to many of the positions that you had. So both sides did a fantastic job. I think if there's one criticism would be at the very end, I know this is all compressed in the amount of time you have. You were so close on things like the valuation, just split the difference, and like that could have been solved for in many ways, and obviously so close to getting things done, but obviously a short period of time. Clint.
All right, well, I want to echo what Joseph said. We figured out that we've sat here for about, at least for me, 20 of these things, and I guess for you, more.
Less. No.
Oh, no, less? Okay. So I have to agree with this being the most sophisticated version of a finals round we've ever seen. And it's not really close on that front. So that part was very, very impressive. And I think the tiny, minuscule differences come down for me as a person who's a negotiation professor here on strategic aspects that relate to negotiation specifically. So I think thinking about you want to, when you're in these negotiation settings, you want to think about setting up the discussion in a way that allows you to unlock the vast amount of knowledge and quick thinking that you can do. And I think dedicating some time to infrastructure of the discussion, laying some principles out on the table before you jump into numbers and some of those things really help. Because again, we've already had it mentioned that, it has a sense of feeling like it moves things along, but I actually do think it causes you to need to backtrack, right? It creates a need for backtrack. And so once those things were unlocked, I thought that the responses, right? Once we had kind of a framework for looking at the different pieces of analysis, the initial offer went up. Christian, as was mentioned, was really impressive, but your responses to it were maybe even better, right? That once those things were unlocked, really impressive the way that you were able to sort of respond in real time to those things. So for me, the very minuscule differences come down to how were we presenting these things, and when were we, in terms of timing, when were the numbers going out, what kinds of things were we saying in support of our numbers as they were on the table, the little pieces that can help persuade people for that last little gap that we needed to get to. And that's, I think, what made the difference. But yeah, really, really fun breath of fresh air around to watch. Really liked it.
Very impressive.
Yeah. And I will say, I'll add one more thing here. This isn't really feedback, but to jump off of something else Joseph said about, hey, this is the first time I've ever said this. If someone wants to go backtrack me, and you can watch whatever videos are available, I give the same feedback almost year in and year out at these things. And this is the first time in many years that I've had we've gotten to get into some of the details. I would just say, really want to emphasize that.
Well, first of all, congratulations to you both. It was a really riveting negotiation. And round of applause for both teams. Congratulations. But the champion of this year's 2025 Halloum Business Competition is Datasphere, Gavin, Bowen, and Christian Welling. So congratulations. And that concludes the final round.